up, guys? What up, Tomato? How we doing, guys? What up? Before I start, what? Oh. Sporkle? One sec. One second. You want me to do this? I can do this. One second. I'll do it on stream. Why is my computer so freaking laggy? I have like a good computer. All right, we're gonna do this Sporkle thing because that's what Akila wants me to do. So I guess I'll do it. So it's the Gettysburg Address. Oh, we have some things on the agenda. I'll talk about it in a sec. Let me just exit out of this stuff because apparently my computer can't handle it. Okay. So transition. So first thing we're gonna do is I guess the Sporkle quiz. It's the thank you so much. Wow, for the resub. I'm gold. Wow. Tier 2. Amazing. Wait, I should put the sounds on. I don't know why the sounds are off. Thank you so much for the tier 2. You guys are the best. So welcome everybody. The first thing I'm gonna do is this thing that Akila said that I should do. It's the Gettysburg Address. Can you name the words? Okay. Ready? Let's see if I can do it. Has Ryan said anything about I don't know. He'll probably be like, it's not a big deal. Ready? 3, 2, 1. Play quiz. 4 score and 7 years ago, our forefathers, other fathers, brought forth upon this nation, this country, on this continent. 7 years ago, our fathers brought forth upon this continent a conceived in liberty and dedicated to the proposition that all men are created 7 years ago, our fathers brought forth upon this continent a new nation, conceived in liberty and dedicated to the proposition that all men are created equal. We we are engaged in a great civil war, testing whether that nation or any nation so conceived and so dedicated can long endure. we are gathered. We are met on a great battlefield of that war. We are a portion of that field. We gather. Last full measure of devotion. A portion of that field, so that may live. It is all together fitting and just, good, proper, that we do. But in a larger sense, we cannot dedicate, we cannot consecrate. We cannot hallow this ground. The living already consecrated far beyond add, detract. The world will little note nor long remember what we say here. Done. It is for us the living. It is for us the living. It is for us the living, rather, to be dedicated here to the unfinished work that we highly resolve that those dead shall not have died in vain. That this nation, birth of freedom, and the government of the people, by the people, and for the people, shall not perish from the earth. Okay. We're doing okay. We got 9 minutes left. 7 years ago, our fathers brought forth upon this continent a new nation, conceived of liberty and dedicated to the proposition that all men are created equal. Now we are engaged in a great civil war, testing whether that nation or any nation so conceived and so dedicated can long endure. We are met on a great battlefield of that war. We have chosen, we have decided, we have resolved, no, to dedicate a portion of that field, died, may live. May live? We have come to dedicate a portion of that field. What is this? Also, where is the okay. We're getting there. 7 years we've come to dedicate a portion of that field to commemorate, to honor, it is altogether fitting and proper that we should do this. Yep. But in a larger sense, we cannot dedicate, we cannot consecrate, we cannot hallow this ground. The poor, the fallen, the fighting, already. But it can never forget what they did here. It is for us, the living, rather, to be dedicated to the unfinished work that which they left. They started. They have. God, I can do this. Which they. The hell. Take a portion of that feel. So that living. Will live. The unfinished work that they dedicated to the great task left before us, that from these, I don't know, sacred, from these we take greater gave the last full measure of devotion. You're highly resolved, these I shall not abide by, that this nation conceived in liberty. Hang on. That this nation. Let's go. We're very close. A visual of which they gave their lives that this nation might. Nice. We have come to get a portion of that field. We have come here to dedicate a portion of that field. Who? For us from these dead. The dead men. The brave men. Nice. Living and dead. Who fought. Who struggled. Wow. That was crazy. Far more. Far. Ability. Our poor ability, a poor attempt, a poor something. Portion of the field, we cannot concentrate, we can have all these gods. There have thus far so nobly endeavored. Have thus far so nobly. They who fought here have thus far so nobly done. Sacrificed. Foursquare. Now we're engaged in a great civil war, testing whether that nation or any nation so conceived and so dedicated can long endure. We were met in a great battlefield of that war. We have come to dedicate a portion of that field to commemorate, to oh my god, why am I struggling? Cannot dedicate. We can handle this. The brave man, living and dead, who struggled here, have consecrated far more for our poor attempt, our poor something, our poor to add or detract. The world will little note or long remember what we say, but so nobly for us to be the great task left remaining before us. That from these sacred, from these noble, from these we take greater, we take increased, we take increased devotion to that cause for which they gave the last full measure of devotion. That we here highly resolve that these dead shall not have died in vain. That this nation once more, or again, this nation under God shall have a new birth of freedom. From these, we have come to get a portion of that field, such so that far beyond. Oh fuck! I'm 8 words away. I don't think. Let me try to get at least one more word. From these brave, from these valiant, from these I don't know. I tried, guys. I'm trying. From these this is gonna hurt me. I tried. Honored as a final resting place above power advanced. Pretty good though, huh? Is that decent? What do you think? Pretty decent? Tell me your thoughts. Be honest. What's the new immunity rule? It's not a new immunity rule. We're just going to go over it again because we're going to have a debate with Ryan Mullally at some point. And so I figured you guys should C+. I feel like I did okay. 97% of all the words. 77 years ago, our fathers. I think it was decent. What do you think? I did my best. It's all right. All right. Just giving you a tough time. Okay, yeah. So on the docket for today, well, it was an honorable mention. No honor. As a final resting place. I should have known that. I knew it was like noble. God, I hate Ryan, says Mantis. Ryan Mullally? A lot of Ryans out there. What is it with Ryans? What is it with Ryans these days? So we're ultimately going to have a discussion on whether Trump versus United States was rightly decided. And I'm going to try to address some of the stuff from Trump versus United States so you guys can follow along. And maybe we can release a video before that debate. And those of you who watch it might have some like greater insight into how I view Trump versus United States and why it was so wrong. Oh my God. These ads. Why I view it was wrongly decided. But I'm also, that's on the docket. So we're going to go through parts of this opinion. We're definitely going to go through parts of this opinion and talk about why it's not an originalist opinion. I didn't know there was going to be a Spinal Tap number 2. I've seen Spinal Tap. This is Spinal Tap 1. It's a good movie. But also open if you guys have questions, legal stuff, especially political stuff. Happy to address anything that you guys have. You've been talking about, whatever. Ryan has never won a debate. Yeah, we reviewed a little bit of his discussion with Steven, and it was just a disaster. And I'm pretty annoyed that he decided to do a victory lap. Will there be a point where you become more vicious with Ryan? He deserves our contempt. I don't know. It's like not... I still at the bottom think that he's a nice guy. That is my fault at times, is that I do the kind of he's a nice guy talk. Do you guys know that he's a nice guy discourse? The original stuff feels manipulative. I do agree. Random question. Why wasn't there a Senate equivalent to Jan 6 committee? So the answer to that is the Democrats. Oh, wow. Thanks very much, Atlas Sars. Very much appreciate your resub. Thank you so much. Did that groups of lawyers that run that podcast have? Oh, I need to reach out to one of them, to Nate the lawyer. But I also wanted to do some goober content, which the legal goobers. Those are my goobers. I'm going over the old immunity decision with a new light, with an eye towards the discussion that I'm going to have, and reassessing it with the particular lens of seeing if it's an originalist opinion. Because I think the debate proposition will be something like, it was rightly decided or wrongly, so Trump v. United States was rightly decided. And with that debate proposition, it depends what we mean by rightly decided. So the question is, why wasn't there a Senate equivalent to January 6th committee? There was a discussion to do that. And there was a proposed that we would do some kind of joint committee, like the commission for 9/11, the 9/11 commission, some joint action. But the Democrats did not want to, the Republicans did not want to do that. They refused to do it. So without cooperation from Mitch McConnell in the Senate, it loses some of its oomph in terms of an independent or a bipartisan joint congressional thing. Do I think the Democrats still should have done something in coordination with the House? I do. And I think that is amounted to I don't know. I don't know what you can say. The Democrats could have, they controlled the chamber, but again, the same kind of mansion, cinema, that stuff. And I don't know that it was a thing that the Biden administration wanted to get bogged down in the Senate when the Senate has the nominations to consider. So when there's not a goodwill from the Republicans, my guess is they want to focus on the nominations and stuff, and the Republicans are being bad faith and don't want to contribute. So I don't really have that much of a problem with just having the one house do it. I'd probably prefer if there was a parallel Senate effort, because to me it really, really matters. But I don't I blame the Democrats for a lot of stuff sometimes in terms of their weakness and shit, but this one, as long as there was at least one of the bodies doing it, I'm not going to lose sleep over it that much. But McConnell should have done it. It's really a shame. McConnell, I hope he feels every time Trump is out there making a fool of the country, doing this tariff situation. Did you guys see that letter he wrote where it's if the courts get rid of the tariffs that I've implemented, all of a sudden we would have all of these jobs losses. Well, these guys delusional. They're all delusional. They're really just lying and delusional. If the Republicans and Dems had a 50-50 Senate, did McConnell really have that much sway? He had a sway over his own caucus, right? The Republicans. And so if the Republicans are pushing back, it's a lot easier in the Senate to stymie shit. So yeah, even though the Democrats controlled both chambers ostensibly, they would have to be willing to do some to push really hard and do a couple nuclear options to really force the issue. And they might have made a reasonable calculation. No, we don't want to do that. We want to focus on nominations and getting through Biden's people. So at the end of the day, when the Republicans were, to their great shame, unwilling to go along with it, I'm whatever. Let the House do it. Let the House be the comprehensive thing. I think it would have been better if we have the Senate, but I'm not losing sleep necessarily over the Democrats' decision. I'm more castigating the Republicans for what they did. Schumer, I think, wanted the Democratic senators wanted to have a joint commission. And when that fell through, we can actually look up. Hang on. So look up McConnell joint congressional Jan 6 committee. At some point on Thursday, Senator Majority Leader Chuck Schumer will call a vote to end debate on the creation of a bipartisan commission to study the insurrection at the U.S. Capitol on Jan 6, it will, barring a massive change, fail, doomed by the unwillingness of 10 or more senators to vote for it. That scenario was set in motion a week ago when Senate Minority Leader Mitch McConnell announced he would oppose the commission in a speech on the floor of the chamber. His reasons were simple and at first glance seemed to make a lot of sense. Here's McConnell. Federal law enforcement have made at least 445 arrests and counting relating to crimes committed that day. Hundreds of those people have been charged. Law enforcement investigations are ongoing, and federal authorities say they expect to arrest at least 100 or so more. Now they've all been pardoned, right? They've all been pardoned. Bipartisan investigations are also already underway, and they have been for months at the committee level in the Senate. So the committee level, right? So there have been, and there will continue to be no shortage of robust investigations by two separate branches of the federal government. It's not at all clear what new facts or additional investigation yet another commission could lay on top of the existing efforts by law enforcement and Congress. This is the CNN article, though. Pretty simple argument, right? There are already two investigations happening. Why do we need a third? And McConnell is right that both the Justice Department and Congress are examining aspects of what happened on January 6th. The Justice Department has charged more than 400 individuals, blah, blah, blah. And there's also a joint investigation being run by Homeland Security and Government Affairs Committee and the Senate Rules and Administration Committee. So independent committees, and they did have released certain reports. So McConnell's not wrong when there are ongoing investigations. He's just being disingenuous. Here's why. The Justice Department is focused exclusively on bringing criminal charges. The joint Senate investigation is focused narrowly on what went wrong in terms of the preparation, communication, and efficacy of the security response. So they all have their particular angle, right? So the Justice Department had their angle on criminality. These other committees, there's like a Capitol Police one. There was also a DOD one. So they all kind of have like a independent purview. But there's like, we want a global commission to get into everything, right? We want some more, like a more universal thing, right? Like that was what's being proposed. What DOJ and the Senate are looking at are pieces of what happened on Jan 6. Yes, justice will continue to arrest people. Yes, the joint Senate investigation will produce a report that likely details a number of breakdowns in law enforcement, but neither will offer a holistic view of not only who broke the law that day and what the police could have done better, but also the factors that led up to the Stop the Steal March, the role that Donald Trump played, whether the rioters were aided and abetted. It is that 360-degree view that a Jan 6 commission could provide, and why a deal to create one was the result of a bipartisan compromise between Homeland Security, Chairman Benny Thompson, and New York Rep. John Katko in the House, and why 35 House Republicans, despite opposition from Trump and the party leaders, voted last week for legislation which would establish the commission. So it was, I think, it was a law that they were trying to enact, and so I think they filibustered it. And of course, the Democrats weren't going to get rid of the filibuster, but you know all that, right? You know all that shit. So that's the story. But it is such a tragedy. It's a tragedy for the country, a tragedy for Biden and McConnell. Of all the legislators in the history of this country, few have done the kind of damage that McConnell has done. McConnell has really fucked up this country. And it's a little bit underdeveloped as a narrative, I think, compared to the Trump narrative, because obviously I think that Trump is like the ultimate person who's responsible for all this. But McConnell should really come down in history as one of the key catalysts for bringing about this era. And like, he deserves your hatred, as in addition to all the Trump people. And it's almost worse that he stands somewhat apart from the MAGA people ideologically. It's almost worse, right? It's like the knowledge of doing something wrong almost makes you more evil. And so when Senator McConnell passes, I don't think we're going to lose much sleep over it, and we'll not have any cherished memories of this dude. This is a bad, bad person. And he played the game. He tried to play the game. He tried to control Trump, and he couldn't do it. And he played with fire, and we're going to have to pay the price for it. That's the sad part, right? Like, he's not going to face any real consequence for it. His name has been dragged in the mud among Republicans, but like, he's not going to have to face the kind of negative effects of his mess. McConnell will get to skate on by, just like keep doing what he's doing, and then he'll die, and then we'll be left up to pick up the pieces. But yeah, McConnell on that, on the Merrick Garland seat, on the general increase in partisanship. McConnell, as well as House Republicans especially, bear a huge amount of responsibility. McCarthy as well. McCarthy was part of this generation of Paul Ryan, McCarthy, and Eric Cantor. These new Republicans, this new generation, Totally failed. He got the gavel for like all of 2 seconds. Paul Ryan got the gavel for all of 2 years. And then they were dropped by their own party, destroyed. And they also bear a ton of responsibility, Paul Ryan included. These guys are big scumbags. And McCarthy in general, like if you forget, right after Jan 6, he like went over to Mar-a-Lago to pay homage to the big man because they thought they could control him, right? McCarthy thought he could control Trump, and he thought he could use him, and then he got destroyed for it. Don't forget John Boehner, same thing, right? The grand bargain. The first thing people forget, the first thing that like Obama did was he tried to have, in addition to the recovery stuff. Excuse me 1 second. Oof. In addition to some of the recovery stuff and the Affordable Care Act, he tried to have a grand bargain with the Republicans. And he had a deal with Boehner, and then Boehner reneged. Because their whole thing is to be in opposition to whatever it is that Obama was doing. They really started this era of obstructionism like we've never seen in the Obama stuff. That's why there's this like, do you guys remember that Key and Peele sketch where he does like a good Obama impression and he does them to do like the opposite of whatever he says? Like, we need to control guns, and like, no, fuck guns, and like cut their tongues off. It really was like that. It was surreal, man. Obama had like 2 years of unified control of Congress, only like a few months really with supermajority, maybe more than a few months. I don't actually remember the timetable there with the 60 senators. And after that, he was fought on every single thing. That was crazy. McConnell literally said, our job is to obstruct the Obama administration. And that's why our job should be that, right? We shouldn't be like voting on stuff that Trump wants. We should be obstructing what Trump wants. That's why like Fetterman is so offensive to me. There were 99 votes for Rubio. That's crazy. That's just insane. We voted for that. Obama's 60 seats were 3 to 4 months, and almost all of that was spent on passing the ACA. Yeah. He was a little bit green, man. Arguably, I think Biden would have been more effective at that time. Maybe. Who knows? Maybe I'm wrong. You look back in history. The other day I was wondering this. You guys might think this is weird, but would we be in a better situation if Germany just like very quickly won the First World War? I think it's like hard to argue. I know it's impossible to know like what could have happened. But if World War One were won quickly by the Germans, World War One, not World War Two, okay? We probably wouldn't have had the Russian Revolution, the Soviet Revolution. We probably wouldn't have had World War II Nazi. Like, World War One was so fucking bad. So, like, even at the time, I'm not a German national. I just, like, wonder if those what-if scenarios, like, wouldn't it have been better for the country if John McCain won in 2008? I don't know. Just in terms of, like, what actually would have happened. Not because I think that Obama in micro wouldn't have been better than McCain, obviously. But, like, knowing what you know now, wouldn't have been better for Romney to win in 2012? Not for reasons that relate to, like, the actual mechanics of the election or their stated policy goals, but just in terms of causality of A leading to B leading to C. We could never say that, like, you know, Romney winning 2012 doesn't lead to some worse Marxist-Leninist that takes over for the Democratic Party. The counterfactual would be Hitler comes from France. Ooh. Yeah, maybe it's kind of hard to make these kinds of historical revisionist or, I don't know, historical replaying the clock. I just wonder, I really wonder what would have happened. There's those moments in history. Another one is like JFK getting assassinated. Like, what if JFK doesn't get assassinated? What changes, if anything? The real what if is if Petraeus never got in trouble with sharing documents, was still eligible to run for Republican presidency in 2016. Oh, really? I didn't know that. I did not know that. Napoleon X. What would have happened? Oh, Napoleon the 10th? New Napoleon? The resentment has been growing. Woke shit just pushed it to a tipping point. I don't know if he would have beat Trump in the 2016 primary, but still interesting. You mean Petraeus? I don't know if Petraeus beats Trump in 2016, man. That's easy to say now, I guess. But, you know, what can I say, man? Okay. Any questions before we get into re-looking at Trump v. United States? The best timeline is 8 Gore, 8 McCain, 8 older Obama. Interesting, Mihatch. I think Petraeus is smart enough and would attempt to woo the populace to some degree. Did anyone think that populism was on the rise among the right wing in 2016? Yeah, I guess. Yeah, the Tea Party was populist, so there was a big populist sentiment that was growing. I don't know why I asked that. Yeah, there was a huge, like, Sarah Palin was that. The Tea Party people, yeah. So, sorry. I thought Ted Cruz was going to be the nominee. I unironically think that would have been much better for the country if Ted Cruz was the nominee. I think we're crazy. Like, in retrospect, there are very few people, like, I think Trump is, like, one of the worst people that we would have wanted to come out of that process. I'm trying to think of other Republicans that would have been, like, worse to come out of that process. I truly think that there's something about Trump that makes him, not ideologically, but just in terms of institutionally, structurally. Sam Harris always said this hypothetical that I totally agree with, which is I would take a random citizen over Donald Trump. Which is like a wild thing to say, right? But I really would take random citizen over Donald Trump. Would you? Tell me what you think in the comments. I miss the old crazy Republicans. Yeah. When he said that the first time, Harris has always been pretty based about like how he will contextualize his thoughts about Trump. He has a way of putting it that I find, and one time he said, like, holy shit. How he said it was like, do you know how horrible that could go? A random citizen, and he still would do it. He just has a way with it, man. Yes, 100%. Yeah, easy. Okay. So we're going to walk through a little bit of this opinion, and please stop me. Thoughts on Sam Harris moral landscape thing? I think it's kind of cringe based on, and I'm not a philosophy guy. I'm just a mere Padawan. But the notion of an objective moral philosophy is just something I don't understand. Like, I don't understand what people mean by objective morality. Given a set of preferences, I can understand like moving in one direction or a moral landscape subject to an initial set of preferences. But I don't really know, like, he's kind of assuming the whole objective morality. Like, he goes, if you think that there's something about morality that isn't the worst of all possible worlds, I don't know what you're talking about. The most, like, but that's the whole question, isn't it? Thank you so much for the subs, guys. So, yeah, I mean, like, no doubt that there are some objective things you can say about morality, I guess. Objective meaning, I don't know, necessarily true or whatever, given a set of preferences. But I just don't think that he's... And I think there is a problem of cultural relativism, but I don't think that, as I understand the what he's saying, that it's, strictly speaking, addressing the is-ought distinction, right? I don't think he successfully bridges that is-ought distinction, or whatever that would mean. I actually don't even have a conception of what objective morality even means, outside of like a reference point of some kind. Hi, Mr. Pisco. What up, pound cake? Who wants a sub? Oh, you're sub donating? I think everyone wants a sub. I like Sam for how he thinks, not what he thinks. He broke his own credibility. Yeah, I like a lot of the things that Sam says, but sometimes it can be very cringe. Okay, so please pepper me with questions. Oh, thanks so much for the super chat. How do you think Trump will go down in history? Will he be condemned? Or will there be numerous apologists like we see with the Confederacy? I think Trump will be beloved by a lot of Republicans for some time. I don't think that there will be a re-examination of Trump's from the Republican perspective for many decades. You guys can tell me if you disagree with that. I think that we are firmly in the Trump era now. That he is the center of political gravity, not just for Republicans, but for Democrats too. Like, you see Gavin Newsom tweeting like Trump, and we all like it. We all think it's base as fuck. And he's, I guess, ridiculing Trump, but he's also kind of emulating him. Have you guys heard that phrase, imitation is the sincerest form of flattery? So I don't think that the Democrats in every respect are emulating Trump, but there are aspects of Trumpism that is seeping its way through politics generally, regardless of political ideology, regardless of political party. And I think you have to be kind of blind not to notice it. So in the same way that you could say Theodore Roosevelt and FDR were consequential presidents. Thank you so much for the sub, Pound Cake. Super appreciate it. I think Trump is a defining change in the political era. And it's one where the Democrats are going to have to and will align themselves in a different way, similar to how Republicans are. So, yeah. And it's changing America. So, I kind of find it, I said this before, but similar to COVID, there is no going back. You can't go home anymore. You can't go home anymore. Home is different now. Come gather round, people, wherever you roam. Yeah, I mean, so we'll see. Hopefully, we can get back to some based era of patriotic, democratic rule. But no. Did Mark Cuban do a tweet? Should we check Mark Cuban's tweet? And of course, we condemn all political violence, no matter what, no matter the context. What is it? Mark Cuban? The new norm ain't the same as the old norm. Mark Cuban. What's the tweet? The tariff tweet? Is this the tweet we're talking about? I support tariffs that protect our strategic industries. I think across-the-board tariffs are awful. I think I probably agree with someone with that. What's the crazy tweet? Is there a crazy tweet? I will add that I would make an exception if the repurchased shares charge higher tax on buybacks. Yeah, I don't know what tweet you're referencing. But if you direct it to me, maybe I'll know. So, folks, any questions before we get started? Any big cues? The billionaire tax? I mean, guys, I think that would have legal issues. The billionaire tax proposals. There's potential legal issues for those kinds of taxes. But it doesn't mean we shouldn't propose them. At least gold isn't tariffed. Okay, let's get into Trump versus the United States a bit. We're going to the opinion, not the syllabus. So we can really inquire whether this is an originalist opinion, whether we agree with it or not. I feel like we've started this opinion numerous times in streams, but I really do want to make sure you guys get why I think it's so damaging and why I think it's so wrongly decided. And so we're going to scrutinize this majority opinion. And there'll be a debate on this between me and Ryan. But the reason we're revisiting it is because I saw Ryan Mullally do a victory lap on Twitter about how he owned Destiny in a discussion on this topic. And it just pissed me off, man. I'm going to not let it take it so personally, I guess. But it just makes me mad that people defend this shit. And supposed originalists, supposed people who care about originalism. Let's start with a little bit of background on originalism. Like, originalism is a type of judicial interpretation or philosophy that I'm not going to say as its exclusive interpretive tool uses text and meaning as understood at the time of the enactment of a particular legal instrument. I'm not going to say that's the only tool in the toolbox of an originalist necessarily, but that one of the main tools in the interpretive toolkit of an originalist is to go back in time to when a particular provision of law was enacted and to make interpretations based on that time, either the text as publicly understood at that time or as the lawmakers intended it to mean. Different flavors of originalism. But one thing that you consistently see in originalist opinions is using historical evidence. This is what the framers said. Citations to the Federalist. Citations to contemporaneous dictionaries. So for the framing generation, looking to 1787, 88, 89, around that time, looking, if you are examining the Reconstruction Amendments, to 1868. If you're examining statutes, and there is a form of originalism that that applies both to statutes and to constitutional provisions, it's the same thing. That we look to the framing generation that values text and what that text means to the people who enacted it. But originalists often disagree. And oftentimes the historical record is not available to give you a bunch of ways to interpret arguably ambiguous text. However, there are things that I think should cause one to be doubtful about whether or not, the mere absence of on-point history, whether that absence should lead us to think that they didn't consider something or that they didn't include it in their conception of the thing. That seemed a little abstract, but we'll get into that for purposes of the immunity doctrine because it will be relevant. But it is a style of judicial philosophy and interpretation that says we don't want judges just making shit up. We don't want them just inventing out of whole cloth their own law. The purpose of a judge is not to create the law, it's to interpret the law. It's a little circular, though, because what does it mean to interpret the law? We're trying to establish, at first blush, what is the quote-unquote correct way to interpret the law. And so you have to, at base principles, justify why originalism is better. And I don't know how you do that without appealing to either outcomes or the notion that you just structurally do not want unelected and unaccountable philosopher kings making decisions. But of course, they're making decisions even if they're taking an originalist lens. But the notion is that grounding them to the enacting generation of any particular point of law, that grounding them there will make them less apt to stray and just invent shit by themselves. That there's some like star in the sky that they can follow, a North Star. Someone who's not ideologically committed to originalism, although I will say, given the court's recent decisions, we need to adopt everyone's an originalist now, kind of, because that's what is winning the day in the Supreme Court. And so, as a matter of just pure power and practicality, you have to contend with originalism because that's where the court's makeup is driving you towards. But for someone who is not necessarily ideologically committed to originalism, you would just say, okay, well, that evidence is but one of many different interpretive tools that we could use. Another being a kind of more purposivist look at the structure of the Constitution and why, at a level of abstraction higher than perhaps an originalist, a particular provision is enacted. The greatest example of this is cruel and unusual punishment. Is cruel and unusual punishment, was the intention of this provision of law to merely ratify the then existing standards of the time, that whatever cruel and unusual meant to the founding generation, not cruel and unusual subject to the, intents and desires of the current population. And that's one example that Justice Breyer often uses in his conversations with Justice Scalia, where they had this long, talk series where they discussed and debated the best interpretive tools. So that's the backdrop here of what I'm specifically critiquing. I'm critiquing potential hypocrisy in those who would claim originalism as their mantle and also support this opinion. I do think that there are contradictions in that notion. Become a teacher. Oh, thank you. So let's get into the opinion. Remember, this case is about a prosecution of a former president. And that's how Chief Justice starts. This is a majority opinion that has 5 justices signing on to the majority opinion. So the majority opinion is the final statement of law of the court. There's a concurrence from Justice Barrett, which gets a lot of attention, and there are some dissents. And so we're going to take the opinion of Chief Justice Roberts as the law, because it has, we can count to 5. 1, 2, 3, 4, 5. 5 justices out of 9 signed on to this opinion. And the chief starts. This case concerns the federal indictment of a former President of the United States for conduct alleged to involve official acts during his tenure in office. Alleged to involve official acts during his tenure in office. So it's not about a current president. It's about a former president. It concerns chiefly the federal indictment and for allegedly official acts. The Supreme Court continues, we consider the scope of a president's immunity from criminal prosecution. Just because you have these limitations, this is a kind of a factual backdrop here, doesn't mean that the immunity doctrine only applies to federal prosecutions. You should think of this case as chiefly involving immunity with respect to both federal and state prosecutions, and there's reasons for that. Although the factual backdrop doesn't involve a state prosecution. Thank you very much. Yeah, I streamed for more than an hour. It very much relies on the structure of the Constitution and the federal Constitution, which there's no reason why it would be limited only to federal prosecutions. Section 1 of the opinion here, this is just stating the facts. Kind of the facts and the procedural history here. And so we're going to just go through very briefly some of the facts. Remember, the indictment is about Trump's attempt to overthrow the election. There are 4 counts, and they relate to 5 primary means of trying to overturn the election. The first means is using false slates of electors to change the outcome from Biden to Trump. So that's the first, so 1, you could call that false elector scheme. Number 2, Trump organized fraudulent slates of electors. So this is, this is, you could call that false claims. My bad. 2 is the false elector scheme. 1 are the lies, knowing lies, to get the state legislatures, lies for the states to change their electors. Different than the false elector scheme, right? This is lying intentionally and trying to coerce state actors like Brad Raffensperger and different various state legislatures to try to change the results of the election. The second is this kind of false elector scheme to both create these false electors and also to transmit the false certificates to the vice president. Third are these kind of like DOJ interactions. So the first are the lies to the states. Second is the false elector scheme. Third are the kind of DOJ machinations. Fourth is the vice president declaring that Trump won the election. So the fourth, you can consider that like VP. And then fifth is Jan 6. You got that? So 1 are the lies to the states. 2 is the false elector scheme. 3 is the DOJ shit. 4 is the VP stuff. And 5 is the kind of Jan 6 related methods. Based on this alleged conduct, the indictment charged Trump with a conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, actual obstruction, right? So there was a conspiracy to defraud, an actual obstruction, and a conspiracy against rights. And Trump argued presidential immunity on like all the conduct, basically. So we're going to skip that stuff and go right to the analysis. So 1 is kind of like the factual and procedural backdrop. Now we're on to section 2 of the opinion. This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency. We are called upon to consider whether and under what circumstances such a prosecution may proceed. Doing so requires careful assessment of the scope of presidential power under the Constitution. We undertake that responsibility conscious that we must not confuse the issue of a power's validity with the cause it is invoked to promote, but must instead focus on the enduring consequences upon the balanced power structure of the republic. So this should immediately clue you in, guys, that this is not a purpose analysis. This is not looking into why a power is being invoked. When I bring up these hypotheticals of bad faith actions, right, using a power in bad faith to promote some other criminal end, the reason why I use those hypotheticals is because it's pushing at the very distinction that Roberts tells us doesn't matter in this context, which is why you would do something, right? So it's trying to insulate the court in this line. We don't have to agree with what Trump did to conduct this analysis. We don't have to celebrate the cause that Trump is trying to promote in his use of these powers. Our analysis is focused primarily on a power's validity, not the cause that power is invoked to promote. So one of the reasons why we push all of these crazy hypotheticals about SEAL Team 6, where there's some bad faith invocation of, for example, the military authority of the president, or some bad faith invocation of the pardon power, or the power to treat with other nations is because Chief Justice Roberts tells us to put our blinders on, to consider the presidential authority kind of in isolation of the cause that it is invoked to promote. There's a problem with this because it assumes that the power itself is unconnected for the cause, right? It assumes that presidential powers don't turn on why you would do something, right? Perhaps a power's validity does turn on why a power would be invoked. Whether you have the power, for example, of self-defense in some contexts, right? I know it's different than an official power. I'm just trying to give an example. Turns on why you're using that deadly force in that context. And so whether your self-defense claim is, quote, valid or legal, it does matter why you're invoking it. And so this distinction, I think, is an indication of the conservative majority's court's increasing push towards formalism and hermetically sealed boxes. I don't want the court ever to inquire as to the purpose of why the president does something. That's for the president themselves to decide. And we don't ever want to be questioning the motivations of the president. It's similar to their rationale for the firing power and the removal authority. That authority belongs to the president and no one else can touch it except in these very limited circumstances. So you should take that as an indication of the court's leaning towards formalism and hermetically sealed boxes of authorities where the other branches do not really get a say in how those powers are executed, including in this case Congress and arguably the courts themselves. Here there's a citation to Youngstown Sheet and Tube Corporation versus Sawyer. This is the famous case examining presidential authorities, and specifically to Justice Jackson's concurrence. Justice Jackson, he offered this concurrence, which has become the kind of statement of law, and that examines executive power, the presidential authority, in a kind of tripartite way. That when the president is executing some authority granted to them directly by the Constitution, the president's use of that authority is completely in his discretion, in their discretion, not really subject to constraints by Congress. This case, if you recall, dealt with the seizure of a steel mill by the Truman administration. Well, where in the Constitution does the president have the authority to seize a steel mill? Well, it doesn't really say directly that the president can do this. So that's call that Youngstown 1. I'm just going to make sure that I'm correct about the labeling here. Just give me a second. We'll do a little cut if we ever do a video edit here, where I can almost ready, folks. Almost good. All right, one sec. chill, folks. I'm just pulling up some notes I wrote a long time ago that I always go back to. Okay. So, yeah, I'm right. So Youngstown 1 is this kind of area, you can call this category, where the president has been directly authorized by the Constitution to take some action. And in that situation, like, you're not supposed to really question his authority in that instance. Youngstown 3 is where the power is not held, is directly put into the hands of another branch. And typically in this analysis, it's Congress. That when Congress has the authority, the president doesn't have this authority, and then the courts are free to say so. And Youngstown 2, this kind of middle category, is when there's some ambiguity or some overlapping spheres of authority. And then in that situation, you see to whether or not like Congress has specifically spoken on this issue. And if so, you listen to Congress. If not, you might defer to the president in that case. There's no general emergency power for the president to just seize steel mills. You want to go to Congress to suggest and to see whether or not that authority has been granted to the president. And so because we're kind of in a Youngstown 3 situation, again, this is a concurring opinion, the president's seizure is illegitimate. Got it? That is not a criminal case. That is a case challenging the legality of the seizure of the steel mill. The parties before us do not dispute that a former president can be subject to criminal prosecution for unofficial acts committed while in office. They also agree that some of the conduct described in the indictment includes action taken by Trump in his unofficial capacity. So the court, the very next paragraph, is suggesting that there's something called official conduct, official acts, and actions which are unofficial, right? So there's actions. Actions are things the president could do, and they can be put into the category of official and unofficial. They, that is the parties, disagree, however, about whether a former president can be prosecuted for his official actions. Trump contends that just as the president is absolutely immune from civil damages liability for acts within the outer perimeter of his official responsibility, he must be absolutely immune for criminal prosecution for such acts. This is cited in a case, Nixon versus Fitzgerald. In that case, there was a firing, a termination, I believe, that occurred. And I think there was a lawsuit for damages against the president for like wrongful termination for this. And what the court determined in that case is that there's absolute civil immunity for these kinds of official acts for civil damages cases. Similar to the absolute civil immunity that prosecutors generally have for their prosecutorial decisions and that judges tend to have under common law for those determinations. Now, as I understand those doctrines of absolute civil immunity, I understand those doctrines to be common law doctrines. Now, they don't have to be. There could be statutes that grant that authority, but this developed out of the common law, by and large. And so I don't know why, in the structure of the Constitution, there's some basis to believe that absolute civil immunity is contained within it. If there such a thing existed, I would point to federal common law, perhaps, for the source of that immunity, if such exists. That said, you don't have to grant Fitzgerald, but know that the court is making a direct parallel, a direct analog to Nixon versus Fitzgerald. This case establishing absolute civil immunity for actions, official actions taken by the president. And Trump argues that the bulk of the indictment's allegations involve conduct
in his official capacity as president. Although the government agrees that some official actions are included in the indictment's allegations, it maintains that a former president does not enjoy immunity from criminal prosecution for any actions, regardless of how they are characterized. This is something I agree with personally. We conclude that under our constitutional structure of separated powers, the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office, at least with respect to the presidential exercise of his core constitutional powers. This immunity must be absolute. As for his remaining official actions, he is also entitled to immunity. At this current stage of proceeding in this case, however, we need not and do not decide whether that immunity must be absolute or presumptive. So there's one common misconception of this case that has been allowed to persist, which is that the court in Trump v. United States established presumptive immunity for the non-core, right? So here are the two different boxes. Box number one is official or not official, right? And then there's core and non-core. These are the boxes, okay? So first, whether it's official or not, and if it's official, whether it's core or non-core. And they don't decide that non-core official action is subject to presumptive immunity. We need not, and do not decide. So it's possible that non-core official actions could be absolute immunity. So there's this, what I'm calling the misconception is the notion that the court decided that there is presumptive immunity. The court did not decide that there's presumptive immunity for non-core. The court said there is at least presumptive immunity for non-core official actions, but there might be absolute. And there is absolute for core. So for core official, this is absolute. And for non-core, at least presumptive. At least presumptive. And that's how you should think about an action. First ask official or not official. Then ask core or non-core. If core, absolute immunity. If non-core, at least presumptive immunity. That's the sort of tree here. Note also what the court is saying here. We conclude that under our constitutional structure of separated powers, the nature of presidential power requires. So this is a structural argument, not a textual argument. And I'm not saying that originalists are never making structural arguments, so don't hear me to say that. But this is a structural argument that basically says out of necessity that the structure of the Constitution necessarily requires that a former president have some immunity. So this is a question of basically that it's impossible, right? It requires it. The nature of the power that we have requires some immunity. So in my opinion, this should indicate the primary mode of analysis by the court here, which is one of results. That if this immunity did not exist, it would be incompatible. Like what would result from not having at least some immunity for official actions, that those results would be incompatible with the nature of the presidential power. This to me indicates, the notion that the nature of the president's power requires it. This is not suggesting that's what the originalist understanding was. Or that the originals, the founding generation, thought what they were doing, or that the public understood that what was happening at the time of the framing was this criminal immunity. It's basically saying it could not be otherwise. Because if it were otherwise, the results would be incompatible with the nature of presidential authority. That to me is a signal this is not an originalist framing. It's a statement about what is required to understand the constitutional executive authority. Not what the framers thought they were doing, not what the founding generation wanted to enact, and not what the general public understood the text of the Constitution to convey. And be on the lookout for the traditional sources of authority for originalists, contemporaneous dictionaries, statements by the framers, the Federalist Papers, debates in the ratification. Article 2 of the Constitution provides that the executive power shall be vested in a president of the United States. The president's duties are of unrivaled gravity and breadth. This is Trump versus Vance. This is not J.D. Vance, okay? Don't be confused. This is Trump versus Cyrus Vance Jr. Cyrus Vance Jr. was the Manhattan District Attorney before Alvin Bragg. And he had sought a subpoena to obtain Trump's tax returns and obtain his taxes for purposes of a criminal investigation. They include, that is the president's duties, for instance, commanding the armed forces of the United States, granting reprieves and pardons, appointing public ministers and consuls, the justice of the court, and officers of the United States. He, meaning the president, also has important foreign relations responsibilities, making treaties, appointing ambassadors, recognizing foreign governments, meeting foreign leaders, overseeing international diplomacy and intelligence gathering, and managing matters related to terrorism, trade, and immigration. Interesting inclusion here of terrorism. Right? Where in fact is in the Constitution the terrorism provision. Now, I don't deny that the president has such authorities, but just a very interesting inclusion there. Domestically, he must take care that the laws be faithfully executed. And he bears responsibility for the actions of the many departments and agencies within the executive branch. He also plays a role in lawmaking by recommending to Congress the measures he thinks wise and signing or vetoing the bills Congress passes. No matter the context, the president's authority to act necessarily stems either from an act of Congress or from the Constitution itself. And that makes sense. The office of the presidency didn't exist before the Constitution, which is unlike the state governments, the governors of the various different states, which don't owe their existence to the federal Constitution. In fact, the federal Constitution assumes the states are a given. In some ways, the federal Constitution doesn't make sense unless you understand that there are state governments that have their own domains of sovereignty. And once again, citing Youngstown, that the president's authority doesn't exist independent of either the Constitution or the laws made pursuant to the Constitution. And yeah, so for those of you who didn't catch up on this flow chart should tell you the first question is official or unofficial. Next, core or non-core. If core, absolute immunity. If non-core, at least presumptive immunity. And maybe absolute. The court doesn't decide. In the latter case, that is, when the president's authority stems from the Constitution itself, the president's authority is sometimes conclusive and preclusive. So this is where they're getting the language. When you hear conclusive and preclusive, they are citing Justice Jackson's concurrence in Youngstown. Note that Justice Jackson's concurrence in Youngstown, that is not founding generation documents. That is not founding generation debates, and it's not about criminal immunity. It's saying no more or less than there are some things what the Constitution says only the president can decide to do. And we agree on that. Pardons, right? Being the commander-in-chief. Only the president can do that. I want to stress, that is not criminal immunity. When the president exercises such authority, that is his conclusive and preclusive authorities, that is when the Constitution itself grants the president authority, he may act even when the measures he takes are incompatible with the express or implied will of Congress. So Congress could, if it wanted to, criminalize a pardon, and it would have no effect on the president's pardon as such, because the president is the only party that can pardon. And that is no more or less than once again repeating that there is a separation of powers. So don't get tripped up on this. We're just repeating the same thing over and over and over again. What Youngstown is acknowledging in the context of the Steele seizure case is saying, yeah, sometimes the president decides. Congress can't just make the presidency a nullity. Congress couldn't, if it wanted to, pass a law tomorrow that says, hey, the president is no longer the commander-in-chief. So Roberts is going and stressing here the language that Youngstown stands for the proposition that there are some things the president can do which Congress can't question. And you don't have to, you do not have to disagree with that basic notion. You don't have to disagree with the basic notion that there are some things that the president can do that Congress cannot deprive the president of authority to do so. That attempts by Congress to intrude in those areas would be incompatible with the structure of the Constitution. No doubt. You can grant that. Very easy. The exclusive constitutional authority of the president disables the Congress from acting upon the subject, once again citing Youngstown. And the courts have no power to control the president's discretion when he acts pursuant to the powers invested exclusively in him by the Constitution. Cite to Marbury, 1 Cranch at 166. Thank you for the membership. So this is suggesting that there are some areas where even the courts can't constrain the president. And why are they citing Marbury versus Madison? Marbury versus Madison is an early case after the Adams administration where John Adams, in response to a bunch of late session court packing, decides to nominate this guy Marbury to be a justice of the peace. He leaves it on the desk of his Secretary of State. Does anyone know who the Secretary of State was for John Adams? It happened to be John Marshall, the same Supreme Court Chief Justice who would later rule in Marbury versus Madison. And Marbury, for whatever reason, decides to leave that commission on the Secretary of State's desk. Come into power, Thomas Jefferson. Thomas Jefferson nominates as his Secretary of State James Madison. James Madison, author of the Constitution. James Madison, former president of the United States. And Madison does not deliver Marbury's commission to him. And so Marbury goes to the Supreme Court in attempting to use the court's original jurisdiction, that is to come to the court as a trial court, where there is seemingly in the Constitution, there is actually, in fact, areas of original jurisdiction. And the first Congress had passed a Judiciary Act to basically establish the Supreme Court's jurisdiction in other ways, and to acknowledge the Supreme Court's jurisdiction and to create the lower federal courts, to come and request a writ of mandamus to force Madison to deliver the commission to Marbury. It was signed, it was sealed, but it was not delivered yet. You get me? That's a setup for Marbury versus Madison. And in the course of coming to the decision, which is that Madison wins, Marbury loses, the court basically in a bunch of dicta suggests that there are certain acts that are in the discretion of the president that the courts have no power over. For example, the courts can't rein in or can't control the discretion of the president on who he nominates. That act is a discretionary act for the president and the president alone. Because the argument goes that once the president decides something, that the courts can't interfere. That's one of the arguments. And the court says, well, there are some acts where the courts can't interfere, where it's within his discretion. That's how it relates to this. But there are some kind of like merely ministerial acts where the courts can constrain it. And that basically, at the point in time in which Adams nominates Marbury, and where the Senate confirms him, and where they have the commission, they sign it, and they seal it, they put the Great Seal on it. At that point in time, all of the discretionary acts have already been done, and so all that's left is a ministerial act to deliver the commission to Marbury, and so Marbury is entitled to his commission. He's entitled to this delivery. However, the court makes it so that Madison wins, even though they do all this dicta and say that Marbury deserves his commission. And they say that Marbury loses and Madison wins, even though that Marbury's entitled to receive his commission, this loser guy who went to the Supreme Court, even though there is a right for him to receive it, the court, that is the Supreme Court, lacks jurisdiction. And they lack jurisdiction because part of the Judiciary Act that established that you could go to the Supreme Court for writs of mandamus is unconstitutional. So the reason Marbury versus Madison stands for the proposition that there is judicial review and that it is emphatically the province and duty of the Judicial Department to say what the law is because what the court is doing is striking down part of the Judiciary Act to claim that even though Marbury is entitled to his commission, the Supreme Court can't order it. And it strikes down part of the Judiciary Act granting the Supreme Court, purportedly Congress granting the Supreme Court authority to issue these kinds of writs to these kinds of individuals at the time. So that is the setup. So they're not quoting Marbury versus Madison for the notion that it is emphatically the province and duty of the Judicial Department to say what the law is. They're quoting Marbury for the dicta, which is, by the way, I don't even necessarily disagree with, that there are certain acts within the discretion of the president which the courts can't dispute, where the Congress can't intervene. Well, in this case, it's the courts, right? And that when there is a situation in which there's a discretionary act, maybe the court can intervene and order some remedy, but not when there's a ministerial act, but not when there's a discretionary act that's totally committed to the presidency. For example, choosing who to nominate, right? Can you imagine that we went to the court to be like, hey, Trump is not allowed legally to nominate this person. Perhaps once, if they were like literally ineligible for that office because of, they've been under the Section 3 of the 14th Amendment, or because they've been impeached and removed, then you could like do a lawsuit to acknowledge that they're not really in office. But the act of who to nominate, that decision is handed over to the full discretion of the president. So that's what they're citing Marbury for the notion that there are some actions that are beyond judicial management. But again, you don't have to disagree with that, right? That is also not criminal immunity. It is repeating the same thing. This is all repeating the same thing. The president can do some stuff which the other branches can't interfere with. So that's fine. You grant the dicta in Marbury. You grant this basic point about separation of powers in Youngstown. if the president claims authority to act, but in fact exercises mere individual will and authority without law, the courts may say so. Because remember, what is Youngstown if not? Youngstown is the court saying that what President Truman did in seizing the steel mill is unconstitutional. That is the court stepping up and saying this is unlawful. The president can't do this. In Youngstown, for instance, we held that President Truman exceeded his constitutional authority when he seized most of the nation's steel mills. But once it is determined that the president acted within the scope of his exclusive authority, his discretion in exercising such authority cannot be subject to further judicial examination. So note what that means, right? That means that when you decide the president is acting within the scope of your exclusive authority, you're allowed, you can't second guess it if you're the judicial branch. But once again, and fine, maybe you can say, I can understand that. Isn't that falling off from Marbury? But just understand again, the start here, the very start of this opinion, where Roberts says, I'm sorry, the start of the section, where Roberts says, we undertake that responsibility conscious that we must not confuse the issue of a power's validity with the cause it is invoked to promote. So maybe you can grant that if there's something in the exclusive authority of the president, that his discretion can't be subject to further judicial examination. Perhaps. Maybe. But understand in Roberts' view that why a power is invoked, or what the purpose in invoking a power is aimed at, doesn't relate to its validity. It can't relate to its validity. So if you grant that any invocation of a sort of stated power the president has doesn't turn its validity, its legality doesn't turn on the purpose for which it's being used, then you get into this trouble of the bad faith examples, the bad faith hypotheticals. What if you are using a pardon power as a part of a bribe? What if you are using the power to raise arms, right? You're ordering the military to seize Congress. Do you understand? You're invoking the military power to seize Congress for the purpose of seizing Congress. Right? What if you pardon someone for the purpose of facilitating a murder? We'll take the example of using the military authority to march on Congress. Well, what makes that illegal? What makes that unlawful? The president surely would have the authority to march on Washington to seize the Capitol if the Capitol had been seized by the Confederacy. What distinguishes a president ordering the military to march on Congress to occupy it with military force in the example of Congress being occupied by the Confederacy versus a president ordering the military to do the same thing for a military coup d'etat? The only thing that distinguishes those is the motivation of the president in that context. So if we are agnostic as to the purpose in order to determine whether the legality of an action, then we would have to treat that action as equivalent in terms of the powers analysis. That it would be necessarily valid to order the military to occupy Congress because you don't look at the bad faith motive. If the motive is to entrench oneself in power, you're not supposed to look at that to determine whether it was legal or not. And if you think that that is like a mischaracterization of this opinion, we'll get to it, but that's exactly what he's accused of, right? Trump is accused of ordering the Department of Justice to use their official actions to entrench himself in power. In this case, it wasn't the military. It was the executive branch. It was the executive branch to entrench himself in power. And you might be saying, like, well, what are the actual odds of the orders of the military to occupy Congress? Look at what they're doing this week. Do you think Trump would be above that at this point in time? Where are the guardrails? Trump this week is mobilizing military forces in Washington, D.C. And there's no distinction that you should really face as between DOJ and military that I'm seeing in the chat. Because if anything, right, the military is more core than DOJ, right? If anything, military is explicitly enumerated. Now, I think the DOJ is also, it's not directly referenced in the Constitution, but the executive branch, the control of the executive branch is also core, right? And if the executive branch is core in terms of the DOJ and investigations and prosecutions are core, surely the military is core. So you can't look to the purpose of why a power is being invoked, according to Roberts, to determine whether it's legally valid. And that is why all of these hypotheticals work, because this is the kind of horse with blinders analysis that Roberts is pushing us down. And notice, none of that so far is criminal immunity. Later, Bleak. None of this is criminal immunity. The Constitution, for example, vests the power to grant reprieves and pardons for offenses against the United States to the president. During and after the Civil War, President Lincoln offered a full pardon with restoration of property rights to anyone who had engaged in the rebellion but agreed to take an oath of allegiance to the Union. But in 1870, Congress enacted a provision that prohibited using the president's pardon as evidence of restoration of property rights. Understand, this is also not citations to the founding generation. This is not originalism. This is understanding what the 1860s, 70s Congress was doing. It's not the founding generation. But regardless, it's also compatible with my view. Chief Justice Chase held the provision unconstitutional because it impaired the effect of a pardon and thus infringed the constitutional power of the executive. To the executive alone is entrusted the power of a pardon, and the legislature cannot change the effect of such a pardon any more than the executive can change a law. The president's authority to pardon, in other words, is conclusive and preclusive, disabling the Congress from acting upon the subject. Again, grant all they're doing here, all that Chief Justice Roberts is doing here, is repeating the same exact thing. There are separation of powers concerns that make certain acts of Congress unconstitutional in their nature. That is nothing new. It is not, nothing about this commits you to the criminal immunity doctrine that they are pushing. Some of the president's other constitutional powers also fit that description. The president's power to remove and thus supervise those who wield executive power on his behalf, for instance, follows from the text of Article 2. We have thus held that Congress lacks authority to control the president's unrestricted power of removal with respect to executive officers of the United States whom he has appointed. This should also be, they're citing Myers. This is a case, again, not from the founding generation, but from the 1920s. That basically says, even though it's not constitutionally enumerated, the president has the power of removal, the general removal authority. And recognize what Roberts is saying here. Roberts is saying the removal power is another core power. If removal authority is another core power, then firing someone for a criminal purpose can't be criminal. Because you don't look to the purpose of why you would fire someone in order to see if it's criminal. So understand the analysis now. What did Nixon do that was wrong? Nixon fired Archibald Cox, the special counsel. He ordered other people to fire him. And the theory goes that was obstruction of justice, among other things. Remember, there was the investigation from Mueller into the firing of James Comey, the decision to that was taken several times by Trump to order the firing of special counsel Mueller. Excuse me, sorry. Under this theory of the court, any kind of firing decision also is core. So if you condition firing, or if you enact firing for the purpose of obstructing an investigation, for the purpose of self-enrichment, let's say that you fire people who are looking into your son's company to enrich yourself. You tell someone, listen, if you don't stop looking into my shit, you're gone. The court's vision of these powers are an objective analysis. You look at the power itself. You don't look at the motivation behind it. Also citing Youngstown, citing the president's exclusive power of removal in executive agencies as an example of conclusive and preclusive constitutional authority. CF Saylor Law, this is a recent case for the CFPB, noting only 2 exceptions to the president's unrestricted removal power. And that is precedent on Humphrey's executor and probably precedent in Morrison v. Olson. The power to control recognition determinations of foreign countries is likewise an exclusive power of the president. So I'm being repetitive at this point, but I'm just trying to get in your head that he's just saying that there's separation of powers. The president can do some stuff, and Congress obviously can't make that illegal. Congressional commands contrary to the president's recognized determinations are thus invalid. Congress cannot act on, and courts cannot examine, the president's actions on subjects within his conclusive and preclusive constitutional authority. That is a remarkable statement. Actions on subjects within his conclusive and preclusive constitutional authority. Note that language. I'm going to read it one more time. Congress cannot act on, and courts cannot examine, the president's actions on subjects within his conclusive and preclusive constitutional authority. Not the use of those powers per se. Right? Like, you could say, okay, Congress can't examine the pardon power as such, but perhaps you could say that Congress could use the pardon power or the exercise of a particular pardon as part of a case where the president doesn't have authority, for example, to do some kind of criminal conspiracy to murder. Why would Congress be unable to act in that fashion for the purpose of criminalizing something that is outside of the president's control, right? President doesn't have authority to do a coup d'etat. So if the president ordered a military garrison of the Congress for the purpose of stopping all elections, for stopping the transition of power, why couldn't Congress criminalize that? The president, of course, doesn't have the authority to do that. Now, if he uses one of his official powers to achieve that end, an end which is not within his authority, why would the Congress be prohibited from examining it? And why would the courts be prohibited from taking a look at it as well? Again, when you're not examining the powers as such, but just some other purpose or action that is outside of the president's control, right? The president doesn't have the right, doesn't have the legal authority to deprive you of your vote. It follows that an act of Congress, either a specific one targeted at the president's or a generally applicable one, may not criminalize the president's actions within his exclusive constitutional power, Neither may the courts adjudicate a criminal prosecution that examines such presidential actions. We thus conclude the president is absolutely immune from criminal prosecution for conduct within his exclusive sphere of constitutional authority. Now, let me ask you the question. Is there a single founding era document, debate, correspondence, dictionary that the court uses in coming to this pronouncement to prove the case that this is what the founding generation, either the original public meaning of the Constitution, was, or that this was the framers' intent? Is there a single citation to originalist sources? The earliest citation we have is dicta from Marbury. Right? Dicta from Marbury, which says no more or less that there are some things that, courts can't examine as such, which again is not a controversial statement to make. That they wouldn't have the authority to question those decisions as such. But there are no debates cited. There is no Federalist paper cited. There is no statement by Madison, by Hamilton, by Jefferson, by any of the framers of the Constitution or original presidents about what they understood. About, imagine if we were proposing sweeping criminal immunity for the president at a time when we just had and overthrew a king, right? The whole notion of immunity and kingly immunity and sovereign immunity comes from the place that the law emanates from the king. That's why you can't prosecute the king in France. That's why you can't prosecute the king in the United Kingdom, is because that would be a farcical statement to make. Law emanating from the king. The only reason we have law is because the person of the king, as determined by God, allows law to emanate from his person. And so you need to think, if the framing generation, if the public thought that what they were doing when they created Article 2 of the Constitution was creating this kind of doctrine, this official action doctrine, the official unofficial distinction, this sweeping criminal immunity, where are the debates? You would think it would come up. Where are the citations to the Federalist? Where are the citations to the framers? Where are the citations to dictionary definitions of what it means to be a president? There was an immunity transfer from king to the new country in America, but that sovereignty transfer was to the people. It's we the people who are sovereign. But the president, though there are some kingly powers that they have, he is not a king. He is amenable to law. All are supposed to be equal before the law. But what you should know is that this is decidedly unoriginalist. They don't even acknowledge at this point, when they've already made this pronouncement, the distinction between immunity and regular separation of powers considerations. They don't even discuss the dearth of originalist sources. So in what sense is this an originalist opinion? It's a functionalist opinion based on bad reasoning. Do I need to do more at this point to convince you that this is not an originalist opinion? If we are not doing our best to try to transfix and understand and contextualize what the original public meaning of Article 2 is, how are we doing originalism? So I am offended when Ryan says I know this to be a slam dunk. What I did was a slam dunk. Not at all. Not at all. But of course, not all of the president's official actions fall within his conclusive and preclusive authority. As Justice Robert Jackson recognized in Youngstown, the president sometimes acts pursuant to an express or implied authorization of Congress, or in his zone of twilight, where he and Congress may have concurrent authority. The reasons that justify the president's absolute immunity from criminal prosecution for acts within the scope of his exclusive authority do not extend to areas in which his authority is shared with Congress. We recognize that only a limited number of our prior decisions guide determination of the president's immunity in this context. Again, this is not referencing the absolute immunity that they already recognize here. They're pretending, right? Like, look at this contrast. Look at how dishonest this is. Look at how dishonest this is. So they're pretending that unlike in the context of preclusive and conclusive, in this twilight area, there's not a lot of decisions, but there aren't any decisions, right? It's like in part A of section 2, Roberts is making this contrast as though there's this like great deal of sources that have dealt with this question before, but there's not, right? Youngstown is not an immunity decision. And so for him to put this contrast as though, well, in section A, with respect to the core actions, there we'd have something other than a limited number of prior decisions recognizing immunity. But we don't have any decisions before this recognizing criminal immunity for the president, or frankly, for any person. That is because proceedings directly involving a president have been uncommon in our nation, and decisions of this court in this area have accordingly been rare. Remember, this would apply both to sub A and sub B. So even the structure of this opinion, I think, is exceedingly dishonest. The fact that proceedings directly involving a president are uncommon, that applies both to the core powers and the non-core powers. To resolve this matter, therefore, we look primarily to the framers' design of the presidency within the separation of powers, our precedent on presidential immunity in the civil context, and our criminal cases where a president resisted prosecutorial demands for documents. Now let's go to sub 1. The president occupies a unique position in the constitutional scheme, again, citing Fitzgerald, 1970s, as the only person who alone composes a branch of government. So when I say that the opinion of this court is that the president is a branch unto themselves, this is the language I'm drawing from. That this court believes that the president is a branch unto themselves. And so when I put up the hypotheticals, well, why don't the attorney general, why don't the DHS secretary, why don't they also have absolute immunity? If the president is by themselves a branch of government, and all they're doing by giving authority to the attorney general pursuant to an act of Congress in the DHS is granting some of his authority, why does that authority not endow itself with the same immunity that would extend to the president if the president took that decision? If it's true that the president is a branch unto themselves, that they alone compose a branch of Congress, their person, right? Their person comprises the entire executive branch. Why is it that these other executive branch officials don't as well have criminal immunity? The framers sought to encourage energetic, vigorous, decisive, and speedy execution of the laws by placing in the hands of a single constitutionally indispensable individual the ultimate authority that, in respect to the other branches, the Constitution divides among many. This, my friends, is true. They did want an energetic executive branch. No doubt. They definitely did. But it does not follow that you have an energetic branch because of criminal immunity. You have an energetic branch because you put one person in charge. You have an energetic branch because that person has a significant amount of authority. You have an energetic branch because that person is voted on by the entire electorate and they have a mandate and they have a role in legislation. So the president's energy isn't a result of criminal immunity. It's a result of all the structural things that he's allowed to do. And by the way, for those of you like arguing this, you don't have to grant that Fitzgerald was rightly decided. In fact, I think Fitzgerald, as a constitutional matter, was wrongly decided. If they want the president to have absolute civil immunity, I think it should be a matter of federal common law or federal statute. I don't think it's required by the Constitution. I'm just being honest about that. But you don't need it, even if you do grant Fitzgerald, right? Because you don't have to. Because there's no reason to. There's no immunity clause in the Constitution if we're textualists. It doesn't lead to the notion that criminal immunity is necessary. They, that is the framers, deemed an energetic executive essential to the protection of the community against foreign attacks, blah, blah, blah. The purpose of a vigorous and energetic executive, they thought, the framers, was to ensure good government, for a feeble executive implies a feeble execution of the government. This, again, is evidence that the opinion here is results-oriented. Yes, the framers wanted an energetic government. And what the court is saying here is, we think that the general purpose of the framers, not any specific citation, right? This is pretending to be citing to the framing generation for immunity. But they're citing the framing generation for the general principle that they wanted an energetic executive. Bet. They did want an energetic executive. But how we get to energetic executive is obvious by the structure of the Constitution. It's because they have all these powers. That's what makes them energetic. They have all these powers. We don't need criminal immunity. But citing the general proposition from the framers that they wanted an energetic president that wanted good government, right? Like, if all your point is we want good government, not bad government, and the court's like, well, we think what's good government means criminal immunity, that's what I mean when I say it's result-oriented. It's taking this very broad proposition at a high level of generality, which they would never accept in the context of individual rights. They would never accept that in the context of, for example, abortion. This very, very high level purpose. The very high level purpose is energetic executive and good government and not feeble government. Well, fuck. That's a fucking invitation to have Congress have unlimited authority under the Commerce Clause. Because generally you want Congress that's able to do more than the Articles of Confederation. Fuck, that could be, at that point, why stop? If you want an energetic president, why not make him immune for unofficial actions while he's president too? Why unduly coerce him into having to scratch his head about whether something is official or not official? If you take that high level of generality, that we want an energetic executive, and you say, okay, so we're going to, because that's a high level purpose of the framers, that implies criminal immunity? Come on. You would never let liberals get away with that, ever. And you would think if there were a more specific purpose, a more specific intent to have federal criminal immunity, they would have debated it. They would have argued it. Of course, that's not what they meant with the words of the Article 2 or the structure of the Constitution. If they thought that, they would argue it. They argued about all kinds of shit, which is less important, less of import there. If anything, right? The notion of an impeachment where the impeachment judgment clause supposes or contemplates further conviction or further indictment under the law, that they were thinking about these matters of immunity with respect to Congress people. They were thinking about officers being subject to indictment. Why? Because of their corruption. They wanted people subject to impeachment and to subsequent prosecution Not just, and think about it, like, what is an impeachable offense? An impeachable offense relates to the misuse of public trust, high crimes and misdemeanors. These are terms of art that are meant to apply at their maximum, at their zenith, to government officials using their powers for nefarious ends, for ends of corruption, for ends of abuse of power. So even the anticipation that impeachable offenses could also be indictable suggests strongly that there isn't this official, unofficial immunity shit. The framers accordingly, vested the president with supervisory and policy responsibilities of utmost discretion and sensitivity. No doubt. He must make the most sensitive and far-reaching decisions. No doubt. Again, just repeating things we already know about the president. It's a very important job, no doubt. There accordingly exists the greatest public interest in providing the president with the maximum ability to deal fearlessly and impartially. The greatest public interest, right? Public interest in providing. So this is purpose of this. This is legislation. This is saying we think it's a good idea. It's in the public interest to let him deal fearlessly. This isn't saying this is what the framers intended. This isn't saying this is the original public meaning. This is saying it's a good idea. It's a good idea to do this. To make sure the president just does whatever the fuck he wants with his powers. Appreciating the unique risks that to the effective function of government that arise when the president's energies are diverted by proceeding that might render him unduly cautious in the discharge of his official duties. We have recognized the presidential immunities and privileges rooted in the constitutional tradition of the separation of powers and supported by our history. Again, at a general level, no founding sources, no framers, no Federalist Papers, nothing that specifically point to immunity. In Nixon versus Fitzgerald, for instance, we recognize that as a functionally mandated incident of his unique office, a former president is entitled to absolute immunity from damages liability predicated to his official acts. That case involved a terminated Air Force employee who sued former President Nixon for damages, alleging that Nixon approved an Air Force reorganization that wrongfully led to his firing. In holding that Nixon was immune from that suit, our dominant concern was to avoid diversion of the president's attention during the decision-making process caused by needless worry as to the possibility of damages action stemming from any particular official decision. Our dominant concern was diversion. Right? This is policy. This is policy making. Once again, not originalism. We think it's really important for the president not to be harassed. Well, you know what? If you think it's really important for the president not to be harassed, pass a law. If you really think it's important not to be harassed, limit liability through an act of Congress. Limit jurisdiction through an act of Congress to the courts. It's not in the Constitution. Don't pretend that it is. The singular importance of the president's duties implicating matters likely to arouse the most intense feelings, coupled with the sheer prominence of his office, heightens the prospect. Right? This is a probabilistic determination. This is saying we, the court, think that this will likely happen. I'm not saying that's what the framers thought. That is not saying that the framers intended this. It's saying we think that this prospect, that is the court in 1970s, that the president will be unduly harassed because we have a policy vision here. By contrast, when prosecutors have sought evidence from the president, we have consistently rejected claims of absolute immunity. For instance, right, when they sought evidence during the treason trial of former Vice President Aaron Burr, Marshall rejected Thomas Jefferson's claim that the president could not be subjected to a subpoena. But ask yourself why. Why? Why shouldn't he be subject to a subpoena? What should he be? Why should the president be subject to a subpoena? If the president is subject to a subpoena, won't they be unduly targeted, unduly the subject of vexatious litigation? Won't he be potentially cautious, unduly cautious, because of the fear of subpoenas for criminal investigations related to the president or his subordinates? In other words, a court could have just as easily made this kind of results-oriented decision on the prospect that subpoenas unduly chill the conduct of the executive. It is not at all distinguishable. Marshall reasoned that the law does not discriminate between the president and a private citizen. This does not support Roberts here. The fact that all of these evidence cases where we've allowed subpoenas to stand against Trump, we've allowed subpoenas to stand against Clinton, we've allowed subpoenas to stand against Nixon, we've allowed subpoenas to stand against Jefferson. Why did we allow them? Well, it's because the law is equal as to all people. That doesn't mean that there aren't normal separation of powers issues with some congressional or judicial actions. But if we were to take this results-oriented approach that focuses on unduly chilling, rendering the president unduly cautious, it's not at all clear to me that the subpoena cases, the evidence cases, came out the correct way. Because the president does not stand exempt from the general provisions of the Constitution, including the Sixth Amendment's guarantee that those accused shall have compulsory process for obtaining the witnesses for the defense, a subpoena could issue. But why? Marshall acknowledged, however, the existence of a privilege to withhold certain official papers that ought not on ground to be forced into the public view, stating that nothing before the court showed that the document in question contained any matter the disclosure of which would endanger the public safety. But run the originalist analysis here. Where's the evidence of that? Where's the evidence that the public, when they were framing the Article 2, that they intended to have this doctrine or some similar type doctrine? And he noted that a court may not be required to proceed against the president as against an ordinary individual. Similarly, when a subpoena issued to President Nixon to produce certain tape recordings and documents related to his conversation with aides and advisors, the court rejected his claim of absolute privilege, given the constitutional duty of the judicial branch to do justice in criminal prosecutions. But we simultaneously recognize that the public interest in candid, objective, and even blunt or harsh opinions in presidential decision-making, as well as the need to protect communications between high government officials and those who advise and assist them in the performance of their manifold duties. If that's the case, pass a law. If you're scared of the chilling effect on the president, pass a law. Don't claim that the Constitution creates this doctrine of privilege. And in my opinion, this is bullshit too. If you want to protect and insulate the president from these kinds of disclosures, that should be on Congress. But don't pretend that the Constitution requires it. Congress, if it wanted to, could get off its ass and pass a Presidential Protection Act, limiting the scope of criminal liability for official actions to this, and that. They could do the same thing with disclosures. But when you start to do this kind of shit and say, well, it would be really bad if the president had to disclose all this shit in the course of a criminal proceeding, that would be really, really bad. That's just your policy prescription. That's just your vision of policy. It's not an originalist, textual, interpretive lens. And no one can tell me it is. What I think might be unduly prejudicial to the president might not be what you think might be unduly unduly chilling to the president. It's the exact thing that the originalists tell us we shouldn't do, right? Is to just substitute these policy preferences on the presidency as though they are there when they're not. What you can't tell me is that this is an originalist opinion. Not when the kind of citations are all to court cases that postdate the founding and court cases that basically are purposivist and results oriented in their acknowledgement. Congress could, if it wanted to, prevent the disclosure in the federal courts of such records, and even in the state courts. Because the president's need for complete candor and objectivity from advisors calls for a great deference from the courts, we held that a presumptive privilege protects presidential communications. That privilege, we explained, relates to the effective discharge of presidential power. We thus deemed it fundamental to the operation of government and inextricably rooted in the separation of powers. Any reference to the debates in the Constitutional Convention? Oh, yeah, we have this disclosure issue. What if people wanted it? No, they didn't talk about it. They didn't think that's what they were doing. The original public meaning of Article 2 doesn't suggest that's what they understood that they were doing. Preventing the president from disclosing stuff. That's not what they understood. Do you see any citation there? Nothing. Absolutely nothing. All we have are like, this would be a good idea. This would be a good idea, and some decisions on non-criminal immunity decisions take this kind of results-oriented approach to. Criminally prosecuting a president for official conduct undoubtedly poses a far greater threat of intrusion than simply seeking evidence in his possession, as in Burr and Nixon. Really? Again, criminally prosecuting a former president. Notice how Robert strays here, I think, dishonestly. He strays here dishonestly into a current versus a former. Why would criminally prosecuting a former president possess a far greater threat of intrusion than seeking a ton of evidence in his possession? Right? A criminal prosecution has never happened of a former president until now. If we're just looking to history, it doesn't seem like there's a big history of it. Notwithstanding the fact that everyone's understanding was that you could be subject to criminal prosecution. This is new. No one thought that they were immune until now, in 2024 when this came out. Second, there are other super protective processes in criminal law that would prevent these kinds of threats. The fact that prosecution are reviewed by courts, they can be dismissed by courts. The fact that the prosecutors are ultimately answerable to the people through their elected representatives and through their vote for president. The fact that there's more litigants potentially to obtain evidence or to sue in a civil context. Anyone, any Tom, Dick, or Steve. So it's not intuitive to me why, in the main, one is more burdensome than the other, given what is actually likely to occur. And in any event, this is just your feelings. This is just your intuition. This is just Roberts' intuition about what is a great threat, what is a greater threat, what we need to protect against, what we don't need to protect against. It's just policy making. Undoubtedly, it's a far greater threat. Source, according to whom? What I would expect from an originalist opinion is, according to the founding generation, evidence requests were a lot less burdensome than criminal prosecutions of official actions. They thought about this because X, Y, and Z. There's no citation there other than his own feels. The danger is akin to, indeed greater than, what led us to recognize absolute presidential immunity from civil damages liability, that the president would be chilled from taking the bold and unhesitating action. Policymaking. Again, talking about what they think is dangerous, right? You know what I think is dangerous? I think it's dangerous not to allow Congress to impose limitations on the removal authority of the president for independent agencies. I think that's dangerous. If we're just like navel gazing and thinking about what is dangerous in general, I think that's dangerous. But again, no citations to framing discussions, to historical sources, that kind of thing. Although the president might be exposed to fewer criminal prosecutions, no doubt, in the range of civil damages suits that might be brought by various plaintiffs, the threat of trial, judgment, and imprisonment is a far greater deterrent. Source? Seriously, source. I'm not sure about that. That's not intuitive to me. There's a higher burden of proof for prosecutions. There's likely to be less of them. Greater procedural rights in criminal prosecutions. Not at all clear to me. What is a greater deterrent? This is about Robert's intuition about what is likely to deter someone or not. It's comparing what Robert's view is on the likely deterrent effects of both situations. No citation. Potential criminal liability and the peculiar public opprobrium that attaches to criminal proceedings are plainly more likely to distort presidential decision-making than the potential payment of civil damages. Really? How did that work out for the New York criminal case? Didn't seem like, if anything, it seemed like the New York criminal case helped Trump. So it's not at all clear to me that the public opprobrium of a criminal conviction is as intuitive or as obvious here. And why should we be looking to this kind of effects analysis? Why should we? Why should we be deciding what the Constitution says, what Article 2 says, based on our intuitions about the effects of civil litigation versus criminal litigation? The hesitation to execute the duties of his office fearlessly and fairly that might result when a president is making decisions under a pall of potential prosecution raises unique risks to the effective function of the government. No textual sources, no historical sources. A president inclined to take one course of action based on the public interest may instead opt for another. Same thing with subpoenas, same thing with civil cases. Apprehensive that criminal penalties may befall him upon his departure from office. Why is that bad? Why? There's also no dealing with the other side of this, right? They might be unduly encouraged, right? There's such thing as undue chilling. There's also undue encouragement. There are two sides of the coin here. Why are we only interested in one? And if a former president's official acts are routinely subjected to scrutiny in criminal prosecutions, the independence of the executive branch may be significantly undermined. That could also be the result if we're just doing results. If they're not subject to scrutiny, people might think, I don't know, that the president is using his official powers to get bribes. That the president is using his official powers to go after his enemies. What has been more undermining of the independence of the executive branch than this case itself? The confidence in the independence of the executive branch has never been lower than it is now. The framers' design of the presidency did not envision such counterproductive burdens on the vigor and energy of the executive. And again, that's the best they have, is this high-level citation to Federalist number 70, not of specific criminal immunity, but vigor and energy, which is already granted to the president by the explicit textual provisions in the Constitution. The president gets his energy from the grants of authority in Article 2. You don't need to invent something else to give him energy and vigor. You don't need to. We must, however, recognize the countervailing interests at stake. Federal criminal law seeks to redress a wrong to the public as a whole, not just a wrong to the individual. There is therefore a compelling public interest in fair and effective law enforcement. The president charged with enforcing federal criminal laws is not above them, except when it affects his official powers. Marshall's decision in Burr and our decision in Nixon recognize the distinct interest present in criminal prosecutions. Although Burr acknowledged that the president's official papers may be privileged and publicly unavailable, it did not grant him an absolute exemption from responding to subpoenas. Nixon likewise recognized a strong protection of confidential communications, a presumptive privilege, but it did not entirely exempt him from providing evidence in criminal proceedings. Taking into account these competing considerations, we conclude that the separation of powers principles explicated in our precedent necessitate at least a presumptive immunity from criminal prosecution for a president's acts within the outer perimeter of his official responsibility. Such an immunity is required to safeguard the independence, is required, right? Necessarily required. What do you mean by that? Why is it required? We had an effective function of the executive branch before Trump, before this decision, and to enable the president to carry out his constitutional duties without undue caution. Indeed, if presumptive protection for the president is necessary, if presumptive protection for the president is necessary to enable the effective discharge of his powers, when the prosecutor merely seeks evidence of his official papers and communications, it is certainly necessary when the prosecutor seeks to charge, try, and imprison the president himself for his official actions. At a minimum, the president must therefore be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to the act would pose no danger of intrusion on the authority functions of the executive branch. Once again, no citation to originalist evidence sources other than the general statements of energy and vigor in Federalist 70. In no regard an originalist opinion. Just their own vision, their own policy. That if this isn't happening, we'll be unduly chilling the president. But as we explained below, the current stage of the proceeding does not require us to decide whether this immunity is presumptive or absolute. Because we need not decide that question today, we do not decide it. One case is more than 2 centuries does not afford enough experience to do this. All right. I'm going to take a break here. We're going to come back to this tomorrow. Next week, we'll be talking to Connor Points, and we'll try to regularly talk to him on Thursdays. But we're going to keep going through this opinion, and I'll summarize where we're at tomorrow morning. But I hope you enjoyed the ride. I'm a little tired, to be honest, and I don't want to, stay up all night. And we can talk. We can talk to Michael at some point tomorrow if you have any thoughts about this. But we'll be debating our friend Ryan Mullally on this in the next few weeks, maybe this week, maybe next week. So stay tuned, and I'll try to put together a video with all my Trevor United States thoughts. We'll try to make it a little nicer, and I can put in some of my best debate moments on all the debate clips I have on Jan 6 stuff, and maybe put it at the end as a compilation, so you can see whenever I've stumped someone on a hypothetical, whenever I've got so I think it'll be nice to have my full analysis of the case. We can look at Barrett's concurrence, and then have a definitive Trump versus United States examination. But thank you guys so much. I love you very much. Thank you so much for the support. It means the world to me. Rip Akana boy. And I'll see you